make people think that they have no chance of getting out of custody, and therefore they agree to sign. ICE gets that. They go to the person in their jail cell, and they basically cajole and pressure them to sign for their deportation. How many people they've deported. But the numbers that they're announcing are made up because they're actually not currently disclosing the actual statistics that have been disclosed for the last 30 years. Local law enforcement cannot arrest people for immigration violations. They do not have that authority, but they can detain people for ICE to arrest.
Welcome, Happy New Year, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Charles Cook and Greg Siskind. Charles H. Cook is the founding partner of Cook Baxter LLC in Atlanta, Georgia. Chuck served as the national president of the American Immigration Lawyers Association from 2008 to 2009. He has been an adjunct professor of law for more than 20 years, currently at Emory Law School. And he was named one of the top 5 immigration attorneys in the world by Chamber and Partners again in 2022, the best immigration lawyer in Georgia by Best Lawyers in 2022, and is previously named one of the 100 most influential Georgians by Georgia Trend magazine. Greg Siskind is the founding partner of Siskind Susser and has been practicing immigration since 1990. He is also the co-founder of the AI software company Visa Law Ventures. He received his bachelor's degree from Vanderbilt University and his law degree from the University of Chicago. Greg is the author of several books and has helped in drafting a number of immigration-related pieces of legislation. He has also testified as an expert in front of the U.S. House of Representatives Immigration Subcommittee. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting at the end, both Charles and Greg will be taking questions from the audience. If you have any questions that you'd like to submit at any time, you can do so by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here are Charles and Greg to discuss landmark immigration battles against the Trump administration.
Thanks for inviting us to speak. Chuck and I have done presentations together, and Chuck, when the mention was made of testifying in Congress as an expert, you were right next to me as one of the other experts on that panel. So we had that experience together.
We've known each other for far too long, Greg. It's a really remarkable thing. It's great to be speaking here with you today to talk about a topic that is near and dear to both of our hearts, and that is the litigation against the Trump administration. If nothing else, the Trump administration has kept us busy for now the 5th year, and we've got some topics to cover here today.
All right, so I'll be driving the slides, and Chuck, we were debating kind of like what to take out, because this is a you and I are litigating on some of these cases that I think we're going to be mentioning today, but there are just an endless number that you can go down. So we kind of have come up with themes to try and have a variety of subjects that are being covered, but there's no way in an hour you're going to be able to really hit everything, but we'll try and hit the highlights. So why don't we start with citizenship, which was the reason why I think that's going to start with, is it was sort of right out of the gates for the administration as far as the issue that, the first major issue to get litigated.
This has long been a fringe legal theory. Going back to when President Obama came in, but whether he was born in America, John McCain, who was actually not born in the United States, Mitt Romney, whose dad was born in Mexico, Trump, whose mom was born in Scotland. This has come up a lot over the last 20 years or so, but it's very fringe. The idea that if your parents are undocumented, that you're not a U.S. citizen.
Even one time.
I think it's kind of a silly legal argument, but maybe there are 5 members of the Supreme Court that disagree with me. I don't think there are, but I think there's probably at least 2. This is the Trump v. Casa case. It is now at the Supreme Court. It has gone through the district court. Many district courts had this issue. It's now consolidated in Trump v. Casa. Every circuit court that looked at it said, of course, Of course, if you're born in the United States and your parents aren't diplomats, you're a U.S. citizen. This actually goes to the particular phrase within the 14th Amendment, which says that anyone born in the United States and subject to the jurisdiction thereof is a United States citizen. The phrase subject to the jurisdiction thereof is a term of art in the legal world and has meant for centuries children of diplomats. It's literally for centuries. This is not something that the authors of the 14th Amendment spent a lot of time talking about because they all knew what it meant. There was a great article that came out, a law review article that came out last month that analyzed that phrase going back to England in the 16 and 1700s, in which there is actually case law in England basically on this exact same issue. Now, England itself has now done away with birthright citizenship to a certain extent, but ours is embedded in the U.S. Constitution, the 14th Amendment. So Supreme Court, we don't know exactly when they will hear this case, but it will be this spring, and they will be issuing a decision by June 30th, is their typical modus operandi. This is blockbuster. This is the number one issue. This would affect millions of people. It would throw many of our laws into chaos. It would cause ruptures in the familial relationships of tens of millions of Americans. I think for that reason, Greg, Supreme Court is going to say, we're going to stick with what we said in Kim Wong Ark 165 years ago.
There was also another article, I think it was in the Times maybe about 2 weeks ago, that was really fascinating. It was about a Georgetown Law School review. And basically, in a lot of these cases, Supreme Court likes to look at what the intentions were of Congress when they passed an amendment. And they did a study, the Georgetown Law School, and found that there were like 20 members of Congress.
It's great.
Have been not eligible to serve in Congress if in the years immediately after the passage of the amendment, if it was interpreted the way the Trump administration thinks that, and I thought that was pretty powerful, because it's not like post-Civil War the Congress was not, wasn't a partisan body and wouldn't have been perfectly happy to try and kick out.
Absolutely, people from both parties.
So I agree with you. I think that I would put under 5% the odds that the Supreme Court is going to side with the administration on it, but we will see.
My guess is a 7-2 decision with Alito and Thomas in the minority, which
I'm not even sure that they are. This could be a 9-0. We'll see.
Hopefully it's a 9-0 case. I think this is a very simple case. But Stephen Miller, this is one of the things of the hills he's decided to die on, and he convinced Trump to issue this order. The irony, of course, is, was Trump's mom legal? I don't know how she came here.
Well, is Barron eligible?
Is Barron eligible? I don't know. I mean, it
says Melania's citizen. I mean, her pathway, there were questions around that. I mean, there's a lot of ridiculous.
Yeah, I mean, the minutiae you'd have to go into to get a passport. Well, here's my parents' immigration status. So Melania was not a citizen when Barron was born. She was still a resident.
Well, and arguably she was not. She was not invited.
So think about what if the Supreme Court decided to overturn this. I mean, it is a literal chaos in the United States, which is another reason they won't do it. So,
all right, let's move on.
All right, this is we've seen some really a lot of litigation on immigration enforcement. The first one was Trump v. JGG, and this was an appeal of a district court TRO about the Alien Enemies Act, and this is actually ongoing right now in Washington D.C. because. This is with Judge, I can see his face right in front of me, and about now contempt proceedings against the administration. But this was about whether the district court judge ordered the Trump administration in a verbal order, which then appeared on Pacer saying you cannot deport them. And they ignored that because the plane was in the air, and who made that decision and all that. One of them that may have made the decision is now sitting in the Third Circuit Court of Appeals. But the federal district court judge in D.C. is holding contempt proceedings right now, and the Trump administration is appealing that to the Supreme Court whether he has authority to have contempt proceedings against the administration, which of course he does. The Aliens Enemies Act, again, weaponizing a statute from 228 years ago against purported Venezuelan gang members, in which the administration didn't actually have proof that there were Venezuelan gang members being deported. It ultimately, Trump vacated this and turned it into a habeas case. But so the actual expanse and the parameters of the Aliens Enemy Act in 2026 is still unclear. But given the fact that there has to be an invasion going on, and by Trump's own admission, there is no longer an invasion, even if you define illegal immigration as an invasion. It appears that the use of the Aliens Enemies Act is probably on the back burner for now. But it was very hot last January and February when all this action was going on, and we expect to see obviously a lot more immigration enforcement going forward with the Trump administration after this first year, mostly because they have now hired or in the process of hiring something like 20,000 ICE agents, all of whom have little to no experience in immigration enforcement. So we expect to see a lot of crazy stuff going on and a lot of litigation as it relates to the enforcement. We've seen this in Chicago, Greg, where the Court of Appeals finally ruled, you can't do this. And the Trump administration now withdrawn troops. So it can't not putting, National Guard going to different states to enforce immigration law. But the reality is the Trump administration doesn't need the National Guard anymore because he's got a much bigger unit in ICE and sending out, 20,000 new agents into the field. We don't know who these agents are. We don't know what vetting they occurred. We do know that there is very little training going on if they're already out there and been hired. So it's we're going to see a lot of litigation going forward on immigration enforcement. A lot of cities and states, particularly blue ones, are going to be filing litigation. I assume Minneapolis and Minnesota will be filing litigation right now with this massive influx of 2,000 agents into.
Yeah, this has been apparently, as we're speaking, this is apparently the largest ICE action in the country's history that's happening today.
2,000 ICE agents. Apparently, they're going back to the Hilton. They kudos to the Hilton folks for barring them from coming in. You can't be forced to bake a cake, but you can be forced to house troops. Something about the Third Amendment going on right there.
Sounds like.
But it's fascinating because if you bring 2,000 troops into a city like Minneapolis in the wintertime, when nobody's really out and about, now you've got a lot of Fourth Amendment issues going on, and I think we're going to see a lot of litigation on this. I know there's lots of TikToks and videos out just in the last 2 days of ICE basically detaining people on how they look, taking what is called a Kavanaugh stop, coming from a footnote that Judge Kavanaugh put in another immigration case, which we'll talk about, saying that, you're inconvenienced, so what? Became known as a Kavanaugh stop, so much that he was so embarrassed by it that 2 weeks ago in another Supreme Court case, in an unrelated topic, he wrote a footnote about why there should not be Kavanaugh stops.
Chuck, I wanted to, this is why the screen went crazy for a second. I was trying to find this article that was just in Politico maybe 2 days ago, where they did a study and said there are now 300 federal judges, including appointees of every president since Reagan, that have rebuffed the administration on mandatory detention, sort of stemming from this. And there are apparently now 1,600 cases on these issues, on the habeas.
I know, Greg, I've had 100 of those cases in the 3 detention centers in Georgia that we've won. Only, I think it's 13 cases have been denied habeas by 13 different federal court judges, kind of scattered around, all of them recent Trump appointees. I would note on the 300 judges that have granted habeas, There's like 50 Trump appointees. So it's not just like liberal appointed judges. I mean, judges that view the Constitution and they look at what was the Board of Immigration Appeals case. Now, again, this is not it's not one single case here that really stands out, other than the Maldonado Bautista case in California, in which a class action was filed for individuals who entered the country illegally more than 2 years ago, and the judge in that case ruled in a class action with a final decision that they should be given bond hearings, because the Board of Immigration Appeals decision in Yahure, which said that if you came in illegally ever, you can't get a bond hearing, overturning literally decades of law without any forethought. That was written by Keith Hunsucker, a former trial attorney in Atlanta. And it's a terribly reasoned, terribly thought out decision. I will tell you that in the Fifth Circuit, there's at least 3 cases on appeal there, but the Fifth Circuit has not agreed to fast track them. So for right now, because many district courts, many immigration courts are under orders from their boss, the Attorney General, that's it, they're not real judges, they're mere functionaries working for the Attorney General as judges. They have clearly been told to not recognize this class action, which to me speaks volumes about the lawlessness of the administration. There have been 2, by the way, immigration judges that have disobeyed that order and are recognizing Maldonado as a class action and granting bond. So what they're forcing people to do who are detained, who didn't come in legally 25 years ago, is to file a petition for writ of habeas corpus, which are now being, for example, in the Middle District and Southern District of Georgia, where there are 2 large detention centers, automatically granted after a period of 2 weeks. Some courts are granting them within 3 days. One judge yesterday chastised the government for making the same argument they've lost every single time in front of her. She was kind of frustrated by that. How you take out your frustration, Judge, is you issue a standing order. That's how you do that. But it's really crazy to see, Greg, that the bond issues in this the part of the immigration enforcement, in the Trump way, is trying to basically make people think that they have no chance of getting out of custody, and therefore they agree to sign. And we have reports now that even after habeas are granted, before the bond hearing is scheduled, ICE gets set. They go to the person in their jail cell, and they basically cajole and pressure them to sign for their deportation so they can't get out.
So, and I think it's helpful just to give a little background as well, and sort of the context here of the, Chuck, I don't know how many millions of people are currently in removal proceedings.
Oh, there's got to be at least 4 million.
Right. So, in most places around the country, it's many years of waiting before you will get in front of a judge. A lot of people actually, it works, it cuts different ways, but a lot of people, might give up because even if they have a good claim in front of a judge for cancellation of removal or some other benefit, if the administration, if they believe that they're going to be detained that entire time, they're going to want to leave. And so this was, this effort to detain everybody was really the administration's response to the backlog in the immigration courts. So they're trying to get more judges, and they're trying to
wait, Greg. They fired 170 judges.
Well, right. It was a 2-step process. Get rid of all the judges they think that are not on their side, and then replace them with multiple, many more judges that will do the bidding of the administration on there. But that's the problem the administration is confronting, which is that I've said this before, but it's like, from an actuarial standpoint, Donald Trump is very likely not to even be living probably by the time some of these cases are actually heard. I mean, if we're talking about a 10-year wait on there, it's going to be well past this administration before some of these people actually get heard by an immigration judge on there. And the administration knows that. So they are trying to do that. They're using methods like something called expedited removal for people that have entered the country illegally, that have been here less than 2 years. And those people can be removed without being put into getting a day in court. They have been aggressive about, basically putting the onus on the immigrant to be able to prove that they were here on the spot. And even when people can prove on the spot, it seems like they have been not exactly paying a lot of attention to the law.
Well, I will tell you this, Greg, on that. They're running out of people that have been here less than 2 years, basically. So, the reality, we haven't heard much from the expedited removal part of it because they are literally running out of it. But I do have clients scheduled in 2031 for hearings.
Yeah.
That's their first hearing.
Wow.
So,
Okay. Let's see.
Anyway, let's go to removals now. All right. This is actually the nuts and bolts and the meat of the Trump administration, because what they want to report every day, what they want to report in social media, is how many people they've deported. But the numbers that they're announcing are made up because they're actually not currently disclosing the actual statistics that have been disclosed for the last 30 years on removals. But we do know by counting flights, by counting people in detention centers, that it looks like they've exaggerated the numbers by about 100%. They said they deported 650,000 people. It's probably closer to 325,000. And they reported somehow that 2 million people left, which is literally just made up. And because the numbers that come out of their app, because they have this app where you can, quote, self-deport, are in the tens of thousands. So just literally making stuff up to make them feel better about it. But the Massachusetts Supreme Court, Massachusetts District, First Circuit, and U.S. Supreme Court and DPD versus DHS. By the way, the reason you see these initials is a lot of folks that sue on these cases do so anonymously. So just their initials are there, especially if they're asylum applicants. It's illegal to disclose their names in these filings. They have to be anonymous. So you get a DVD versus DHS. So basically what the court did there was block removals, and the Supreme Court agreed, absent notice and an opportunity. So what was happening is this, Greg. Somebody, let's say they're from Colombia, but and they've got a really good asylum claim, but they filed too late. And so you can't get asylum. You can only get something called withholding of removal. What that means is, whereas when you get asylum, later you can get a green card. If you have withholding removal, you have a deportation order. You just can't be removed to Colombia. So for decades, those people have just lived here. They get a work permit. They just kind of live their lives. They'll never get a green card. They just kind of are here. The Trump administration said, oh, you can't be deported to Colombia? Great. We got a Venezuelan prison for you. And so they have been trying to deport people to third countries, whether it be South Sudan or some island in the Pacific, Vanuatu or something, just agreed to take 75 people. Supreme Court said, look, you can't just deport people to a third country unless you give them an opportunity to say, I'm afraid to go to that country too, and then an opportunity to present that to an immigration judge. The government argued that an hour's notice was enough. This is all about Obrego, by the way. A lot of this is about Obrego. And ultimately, the Supreme Court said, you got to give them at least 24 hours. And we've seen ICE follow that. There had been isolated reports. We had one yesterday where an individual from Guatemala had been granted withholding, and they just deported him to Mexico. Just put him on a bus and just put him to Mexico. And they'll have to bring that person back. And so what's happening here is the Supreme Court has made sure that there's at least a minimum amount of due process. There's a saying that I teach my class when I'm teaching my law school class, is that due process is in immigration law is whatever Congress says it is. And Congress has limited due process in a lot of aspects of this. And the Trump's administration's argument is Congress didn't give these people any other due process, so we don't have to give it. Supreme Court stepped in and said, no, there's still a minimum level of due process to have a hearing to protect somebody from being deported to a third country where they might also be harmed. And what we've seen is, for example, some of the group that was deported to South Sudan was subsequently deported to the country that they had withholding of removal from by South Sudan. We're seeing that in Ecuador. A lot of cases now are being pre-terminated in immigration court by saying, well, this person from Mexico, they can present their asylum case with Ecuador because we have an agreement with Ecuador that lets Ecuador take some of our folks, except that's only 75 people a year. You can't, but they're arguing it for thousands of people. So we're seeing a lot of crazy stuff going on. There'll be a lot more litigation on this going forward. Great, a lot more litigation going forward.
Yeah, I mean, I would think a lot of judges are going to probably be a lot more reluctant to let the administration do that if they know, when the evidence is presented that they end up in the country that they're supposed to be protected from going back to, and that, I would think a lot of judges would probably, be reluctant to allow that to proceed.
The South Sudan thing really was shocking to me because that country's in the middle of a civil war.
Yeah.
I mean, it's really just shocking by the Supreme Court that ultimately cleared that removal.
All right. Well, you talked about Maldonado before, so should I move to the next slide?
Let's go to asylum.
Okay.
So we've got the Raice's case from this summer in the district court in D.C., where basically the Trump administration says, we're just not going to grant asylum to anybody. Then anybody coming here, we can just deport because of 212F. Now, this was a radical expansion of 212F. 212F is also 8 U.S.C. 1182F. It basically, Congress gave the president the right to suspend entries to an alien or a group of aliens for whatever reason they want to. This became ultimately Trump v. Hawaii at the Supreme Court. And the Supreme Court said the first 2 times Trump did this, you didn't give a legitimate, we didn't explain in detail why you're going to ban Muslims from these countries. The third time was the charge. Supreme Court said, now you've got enough detail in explaining why you're banning these folks. Yes, you can use 212F to ban folks. But because there's a competing statute on asylum, and asylum is an interior application, it's not an entry issue, district court judge said 212F cannot be used to bar the application of asylum in the United States, period.
And 212F, I mean, that's all these bans that we're here, that you're hearing about, and we'll be talking about some of them. That is the administration's go-to on just about everything now, is that they're doing, even for people who have interior applications pending, they're trying to work their way around that by saying it can be a factor in any kind of discretionary decision, I guess. Chuck, it's not in our slides because it was sort of, breaking news. But, the administration has suspended for people from 39 different countries, asylum applications, non-immigrant change of status applications in the U.S., basically any type of adjudication that USCIS is working on. 212F is being claimed as a factor that they can use in determinations. And there have been the first cases challenging that were filed a couple of days ago, and you and I are working on one that is about to go, this week. But I don't know if that's another way that they're attacking asylum, and that stems from this very unfortunate and sad incident of somebody shooting a National Guard officer in D.C. That all stemmed from that. But that's that's another attack on asylum that we're seeing right now, is via that new proclamation.
I mean, the administration has a motto, never let a tragedy go to waste. And so they use that as an excuse to basically stop adjudicate cases from 39 countries. They're either in the Middle East or they're in, for the most part, in Africa, and randomly Tonga. And basically what they said is, if you're from one of these countries, we're not going to work on your case. We're just not. We're just going to put it aside.
Yeah.
And even if we worked on it, we would say that because you're from one of these countries, that you have a big check negative mark against you because you're from this country. So you have to prove to us why we should exercise our discretion in granting you the benefit to overcome the fact that you were born in Iran. It's illegal, by the way, to do that under our Immigration Nationality Act, which actually forbids nationality discrimination, which is what this is. But they also said they are not going to adjudicate any asylum cases, until they go back and look at all the asylum cases that were granted the last decade, including apparently under the Trump administration. This fellow that committed this horrendous act was actually naturalized by the Trump administration. What more vetting can you do? They keep using this, we're going to vet them more. But they don't explain what that means, and that's because there is no way to vet people more than what they're currently doing. So Jim Hacking filed a lawsuit, Doe versus Noem, in Boston. I think Curtis Morrison has got one filed in the Northern District of California on 765s, and we'll be filing on a giant mishmash of cases as well. I don't know exactly where we're filing yet, but it'll be filed on Friday for about 275 plaintiffs. It may end up being a class action at that point. But it goes to the issue of what the government can do when they don't want to work on the case for their own policy reasons, but which the law requires them to actually work on cases. So it's an Administrative Procedures Act case, and we look forward to filing. It's going to be a lot of fun, Greg. It'll be a lot of fun to argue this case.
All right. Student visas. This is another one that we worked on, but there have been different issues. But why don't we talk a little bit about what's happened to students this year?
All right, let's just start from the beginning. In April, or late March, early April, students began getting emails saying that their SEVIS had been revoked. SEVIS is the underlying basis of a student visa. You register for SEVIS when you go to the consulate to get your visa, and SEVIS tracks your grades, it tracks your classes, it tracks where you live, it tracks where you work. Basically what they said, we're revoking it. They didn't explain why. We're revoking it. And if you revoke the SEVIS, that means their underlying status is gone. It turns out what they did was the Department of State and ICE runs SEVIS, got together and ran a background check on all, I think it's 1.2 million people enrolled in SEVIS, and the 4,000 that got what's called an NCIC, they just ran their names through the NCIC computer, the FBI database, and anybody who had been arrested or had a law enforcement encounter ever, even if it occurred before they got their visa that they were in the U.S. on, they revoked their SEVIS. So we sued. There was probably 100 lawsuits around the United States, and ultimately ICE lost every single one. They reinstated SEVIS for all the students. But as a result of the SEVIS cancellation, the Department of State said, "Hey, your SEVIS is canceled. We're canceling your visas." That's also illegal. And we actually have a lawsuit pending on behalf of about 150 folks right now. Government got an extra time to respond because of the government shutdown. They respond January 30th, but to try to get their visas reinstated. Because what we're seeing is those individuals, if my visa's canceled, doesn't cancel their status. They can stay in school, but let's say they want to go home for Christmas or they have an employer that needs them to travel. They go to the consulate, they're being denied their visa. Even though, for example, we had one of our clients, for example, she called the police because she was being abused by her boyfriend, and they arrested her. Mm-hmm. Ultimately dropped the charges from her, and she lost her visa for this. I mean, it doesn't make any sense whatsoever. And the Department of State's got to follow the rules like everybody else. Now, on top of that, Greg, now what we're seeing, students who graduated in May or graduated in December and then apply for their work permit, which is called OPT, the optional practical training, are now being given, if they're one of these kids, they're now getting a letter saying, "Hey, we're going to deny your OPT because you were arrested for XYZ. Please explain." We just prevailed on a second one of those yesterday with immigration. They granted the OPT, but not after they lost 6 months of work authorization through that process. So there's a lot of stuff going on students. The Trump administration itself is slowing down the granting of student visas. We've seen, I think it was a 17% drop in student visa holders in the United States. And if you hang around on Twitter and you read Twitter, you take that as gospel, you would think there would be no more student visas in America. But student visas keep a lot of universities and colleges alive. They keep tuition down for U.S. citizens, and they let us educate people that become our friends abroad if we treat them properly. That's our story.
Yeah, and the case that you're seeing on the screen right now is sort of a different aspect of that, which is the Harvard versus DHS case. In that case, the administration was trying to threaten Harvard's ability to even accept foreign students and participate in the SEVIS or SEVIS program, however it's pronounced. And Harvard prevailed on that. So that's sort of a different aspect of it, where the administration's targeted universities' ability to participate in the program. And it goes to what Chuck was saying: if Harvard doesn't have foreign students and foreign scholars, their greatness in the world, as far as like being considered one of the top universities in the world, that goes away in a matter of time if they don't have access to the basically this global powerhouse. So that was the case that
Yeah.
was one in the
Very,
summer, and it's worth noting that as well.
if you want to make foreign universities great, take away Harvard's ability to bring foreign students in the United States. It's a great way to lessen our influence in the world.
All right, so this is what we can skip this one because we were just talking about both of them. Chuck, I guess one last question on the students. So, there was a concern as well about that this wasn't a class situation. It was basically the administration seems like they stopped the behavior once they were losing all of these suits. So there was a fear that some of these folks who had their that they were going to quickly end up in removal proceedings or detention. Does that look like that's all over at this point too?
It looks like that the ICE has not moved on anybody who. There have been other people subsequently revoked because they got arrested for a crime, but ICE hasn't moved to detain any of these students that we're aware of. Unless they were arrested for a very serious crime and became an issue of deportation. But no, I haven't. This seems to have melted a little bit into the background. But the issue of USCIS using the same information negatively is still there, and Department of State now changed their own internal rules, the FAM, to allow them to revoke visas basically whenever they feel like it for whatever reason they want without telling you why.
Yeah, and we're still seeing it, on where they have a lot more discretion, such as in the issuing of visas. We've seen things like the social media policies and other things coming that are designed to really thwart a lot of people from coming in. And I would say that if you have any negatives from a law enforcement perspective, a lot of the people that were in our suit had disclosed everything to the State Department, and they got their visas because they were so minor, the issues. I'm not so sure in this environment that would happen with the at consulates today. So just a note of caution. All right, H-1B visas. So Chuck, you and I had been like living in this case. For months, and this is our case. But there were a couple of cases that have been filed.
The Chamber of Commerce versus Trump. So the H-1B visas, the Trump administration decided on September 19th that they were going to create a new fee for H-1Bs coming from abroad. This fee was basically a $100,000 fee that the president imposed under 212F. Now, 212F doesn't appear to give the president the authority to, at least to us, doesn't appear to create fees. Judge Howell in D.C. disagreed in the Chamber of Commerce case, which is now on an expedited appeal to the D.C. D.C. Circuit Court of Appeals. But the folks at the Chamber case didn't do something that we did. So we filed the case first. We filed first global. The Chamber filed a couple weeks later, but the Chamber immediately moved for a TRO without providing declarations of the harm suffered by employers and this fee. While Judge Howell was initially seemed to be accommodating to the Chamber, she destroyed them in oral argument and basically said Trump can do whatever he wants under 212F. If that's the case, if Trump can do whatever he wants under 212F, we no longer have a Congress that runs our immigration system. We have a president who runs our system. And then the next president, let's say he's a Democrat, can say, I'm going to give green cards to everybody with DACA, creating a new category. That's the kind of level of expansiveness that Judge Howell had in the Chamber case. So in our case, we have filed our preliminary injunction a couple of weeks ago. Government response is due on the 17th, on the 10th, I guess due Friday. Our response is due on the 17th. The oral argument is February 17th, I believe, in California, the University of California. We feel very good about our position in this case. The government, by the way, moved in our case yesterday to stay our case while the DC Circuit handles it. I don't think our judge is going to buy that. I think she wants to handle this case. So it is. There's another case that was filed, Greg, by the way, last month by 18 or 19 attorney generals around the United States, by states against Trump administration in Boston. So there's these three cases going on at the same time. What we have, though, Greg, is the problem of the H-1B lottery, which is coming up in March 1. The new lottery, which itself will likely be subject to litigation, at least I hope it is, on how they are going to allow people to have multiple entries in the lottery based on their salary, which will disadvantage people like doctors because they only get a level 1 wage. There's only one wage for doctors. So there's a lot of litigation going on H-1Bs right now. So if you do business immigration, employer wants to know, should I file for my guy in March? The answer is we don't know. One thing we believe is absolutely true is that USCIS cannot charge this fee. This is an entry fee, and USCIS has no jurisdiction to charge an entry fee. The only people that could be charging that is Customs and Border Protection at the time of entry. Trump administration knows this because they put Congress put $1,000 fee on advanced parole entries in certain categories that is paid at CBP at the airport when they come in. So this is a hot and fast-moving topic, Greg, and we'll know more about that by the middle of February.
Yeah, I mean, I think just to add to this, the what Chuck was talking about, sort of this two-front attack on the H-1B visa. I don't think the lottery is going to be as if the administration is successful on the $100,000 fee, there's not going to be a whole lot of people applying for the lottery at all. So it's not going to really matter that much. But
there won't be a need for a lottery at that point.
Yeah, I do think it's worth sort of putting on your radar if you're working in the H-1B space that we are likely going to see some kind of litigation before the lottery happens, because it just is once a year. So if it's not challenged.
I think we lose the right to challenge. I mean, we're not going to have an ability to challenge it if we don't challenge it now.
Yeah, I mean, it's really kind of interesting. So the way the system works, and you could make a policy argument that it's like, for this. The problem is that the Congress basically has had multiple opportunities and on multiple occasions has addressed reweighting how the lottery works. They came up with separate numbers for people with master's degrees. They did other things over the years, and it looks pretty clear that this is not something that Congress anticipated or would want. But even if that were the case, so the way this works is there's 4 levels of wages for H-1B workers: level 1, 2, 3, and 4. The Department of Labor sets those wages, and basically what the administration is saying is that the lottery should be weighted to people that are at the highest level in terms of experience. So the level 4 wage would get 4 entries, level 3 would get 3 entries, level 2. So basically where you are in the wage scale determines your chances of getting it. The problem is that the H-1B program is not, just used for trying to find the most experienced people. It's oftentimes used for very important people that are entry level, such as people that are in AI. And Chuck, you and I were on a conversation yesterday where I was talking about doctors and doctors in the United States. And probably the majority of doctors that get H-1B visas, they don't have they are not doing wage surveys for most physician specialty areas across the country, and they get this default wage. And the default wage is going to be, for the regulatory purposes, you get 1 entry if you're stuck with the default wage, which means that doctors who are coming out of residency programs and are oftentimes paid $300,000, $400,000, $500,000 a year. I mean, it's not like they're not getting a ton of money, but because they have this default wage, a lot of rural communities around the country are going to lose out on getting doctors because of this rule. So there's lots of unintended consequences, and I'm guessing that there will be physicians in this lawsuit that's probably going to be coming.
People will die if we don't win. So we got a couple more topics before we got to wind up and take some questions, Greg. R1s, I know this is a topic you and I have talked about for a long time. There was a case pending in the District Court in New Jersey by the Roman Catholic Diocese of Paterson versus Department of State. And this was over the issue of how Department of State allocated the numbers within the fourth preference category for religious workers as opposed to special immigrant juveniles. And from the inception of special immigrant juveniles, they were kept separate and had separate numbers within the EB4 category. And then about 4 years ago now, when Charlie Oppenheim left, they basically combined the category, and everybody that was a religious worker who would normally get a green card within 3 or 4 years was now in a 12 to 15 year backlog. Yeah. And this went to basically the problem there is if you have an R1 religious worker visa, you're a priest, you're a nun, you're a pastor, you're a music person at a church, you're a missionary, you only had 5 years, and then you had to go home. And it was it wasn't a dual intent visa. So if you started the green card process, you couldn't renew an R. And so this litigation ended up settling this last year by basically getting rid of the 5-year limit and letting people stay on an R1, kind of like staying on an H1B, Greg, forever.
So Chuck, there's actually a relationship between this case and our case, on the H1B case, at the Global Nurse Board's case. We actually have three religious organizations that are plaintiffs in our case, because once this problem emerged where people run out of time in their R1 status and they have no way to extend it and they have no way to get a green card for several more years after that, they have to find an alternate visa category. And so a lot of these religious workers switch to the H1B category. And of course, your typical church doesn't have $100,000 lying around. They pay that fee. So it seems like for a lot of these religious organizations, and there are severe shortages, particularly in the Catholic Church, but in a lot of other faiths, where this is like basically the ability of a church to even function is at stake here. And they've been switching, trying to find any which category that they can use. So this was good news for that. We haven't, but I don't think, Chuck, we have seen any timetables when this changes.
No, we haven't seen the new regulation yet. We don't know when it's going to come out. I don't even see it on the regulatory agenda. So, I mean, hopefully they're enforcing that. Craig, the TPS stuff, this is probably the craziest, most volatile area of litigation right now, because district court judges keep undoing Kristi Noem's TPS terminations, and the Supreme Court keeps canceling them on the shadow docket without explanation. But just this last week, district court in California ruled that Noem's cancellation of TPS for Nicaragua,
Nepal,
and Honduras was not valid. And so all those people who had lost their TPS under the shadow dock, because there was a TRO in place here, now had their TPS back. And that's about 60,000 people. This isn't a small number of people, especially for the Hondurans. They're the biggest chunk of this, and they've had TPS since, time immemorial, so to speak. But the other cases for Venezuela, Haiti, Syria, they're all on appeal right now, having been basically the Supreme Court saying, no, we're not going to put that injunction in place, litigated faster. And these other judges that are handling those cases, I don't know if they're slow walking them or the courts of appeals are slow walking them, but basically TPS is over unless you're from Honduras, Nepal, and what's the third country? See, whatever the third country was, and El Salvador. There's no talk about ending El Salvador's TPS, and you wonder, well, what's so special about El Salvador?
Right.
Who can only play that
he's with the president, and you're, because actually a lot of the people that are here and TPS, a lot of money flows back to the countries that these people are from. So That's why sometimes these countries are perfectly happy to let these programs continue. Chuck,
Oh,
I think
absolutely. El Salvador's kept afloat by that at this point.
yeah, is that oh, we have one more. So this was sort of a I feel like was one of the most interesting cases of the year. And I know that you've been following this pretty closely. So why don't you explain where we are with DACA at the in 2026?
By the way, there are a lot of Texas versus United States cases from Biden. There's a lot of these cases. This is the DACA one. This is the case that started in Trump 1. This is an old case in Trump 1, and then was revived under Biden when Biden redid DACA. Biden followed the law. He followed the APA. He created the process. And Texas, along with I think it was 19 other states, sued and said, DACA is illegal. And at the end of the day, at the Fifth Circuit said, president has the authority to issue DACA. What we don't think the president had was authority to give work permits. Okay. If Donald Trump can issue $100,000 fees, the president probably has authority for work permits. But Texas, you're the only state that presented evidence of harm. You're the only state of all your plaintiffs. You're the only state withstanding. So, Fifth Circuit said, we're sending the case back to Judge Hannon to issue and enter an order about basically, they instructed him to do this, but he asked for more briefing on it that said that will say this. One, you can have DACA in Texas, but you can't have a work permit in Texas if you live there, and you can't, and you're going to accrue unlawful presence. But if you live outside of Texas and you want to travel to Texas, you're fine. You want to work in Texas, but you live in Louisiana, you're fine. Texas went crazy about this because Texas's argument was, hey, we have to cover people in accidents, emergency medical care. We have to give driver's licenses. It costs us money. And oddly enough, the USCIS argued, well, that'll be covered by Louisiana. If somebody's in Louisiana and they get injured in something, well, you just charge Louisiana. That's how the process works. And they'll have a Louisiana license, so you have nothing. So this case has been fully briefed since late November, I think late November. And Judge Hannon is just sitting on it. And so my advice has been now for a month, if you're in Texas, and there are 90,000 DACA recipients, almost 20% of DACA live in Texas. If you want to keep your work authorization, you're going to have to move. You have to physically have a home address in a different state. Does it mean that you can't work? No, you can work in Texas. If you live out, you'll have a work permit. But if you stay in Texas, USCIS is going to take your work permit away. So that's where it is. I thought Judge Hannon would have just a tiny little bit of heart and issue this before Christmas, but here we are in mid-January at this point, and we don't have anything right.
All right. Well, so what are the potential ways to get the judge to actually finish this wrap?
Well, as you probably know, you can't force a federal court judge to issue a decision. There's no way to do that. We learned that lesson in our diversity lottery appeal at the D.C. Circuit, which took 3 years. You can't force them to make a decision. But you can talk about it, and we'll see what Judge Hannon does. Now, a lot of people were concerned, can his decision be appealed? And the answer is no, not if it's within the parameters set by the Fifth Circuit. If he goes beyond what the Fifth Circuit told him to do, well, then that's a whole other issue, but I don't expect that to happen. By the way, Judge Hannon is a senior judge, so he's retired basically. And he should have very few cases in this district. So I assume, hopefully, I'm not going to assume anything. I pray that in January is the time when DACA will resuscitate. So what that means, Greg, is if you didn't get DACA the first time, or you weren't able to apply, or you're one of the 90,000 with a frozen application at USCIS, as soon as he issues an order, you can apply, you can reapply, and USCIS will adjudicate those cases.
All right, I'm going to stop the screen share, and if we, Nina, if we have any questions, we're happy to take them. We do have 5 minutes.
Wonderful. Thank you both so much for all of that information. It's always such a pleasure listening to you. As Chuck and Greg mentioned, we are able to take questions. There are quite a few already, but if you haven't submitted one, you can do so by clicking the Q&A button in the control panel at the bottom of your screen and sending them in. So this first question comes from Hollis. They ask, how have babies born in the U.S. to undocumented parents been affected by the executive orders since Trump signed it?
I don't think they've been affected yet, because it was immediately stayed by many different federal court judges. So it hasn't been affected. Well, I will tell you, though, I mean, Greg probably had this too. I had people call me, women call me, should I have a C-section? Because it was a month out. I think it says effective February 21st. Should I have a C-section so my baby's born before then? Can you imagine making that decision? I mean, that's an insanity. I'll make my baby born early so they're a citizen. It's an insane process. So right now it hasn't affected them.
Yeah.
Thank you. Our next question is, what about vacatur, excuse me if I'm mispronouncing, and remand of the individual, declaratory relief after the fact when declared that the law was illegal? The individual should, quote unquote, turn an illegal rule into a procedural defect, turn the defect into vacatur, and then turn vacatur into lawful redo. I'm not sure I quite understand the question, but it could just be over my head. So
I'm going to copy that question and put it on my law school final. Which vacatur are you referring? I don't know what he's referring to. I don't know which particular case are you referring to on this, or is this a Civ Pro question? All due respect, I got a B+ in Civ Pro, so 40 years ago. So I'm not going to worry about that. Phil Rizzo has a question, Nina. This is with government. There's three of them actually. With the government unconstitutionally labeling ICE observers as domestic terrorists, how can this hurdle be overcome and pushed back against? Everyone has a right to peacefully petition the government for redress or grievances, and we know from free court precedent that law enforcement officers can, in fact, be recorded. This is, I think, a situation where you just simply have to be taught to exercise your rights. And if ICE abuses that process or they hurt somebody, you file a lawsuit against them. You file a Bivens action against ICE. And I would suspect that we will see, Greg, a parade of Bivens actions coming out of Minnesota. Two, Greg, is how will the Supreme Court find a way to give Trump what he wants? I on birthright citizenship, I don't see that happening. I really don't.
Yeah, the arguments are pretty weak. You could argue, that that's what Congress intended. I think that's a loser based on what we talked about earlier. You could argue that the literal reading of a statute allows for that interpretation, but I think that it's pretty plain what
the argument is. Yeah, the argument is that these undocumented immigrants aren't subject to the laws of the United States.
Well,
really?
You throw them in jail, they are.
Really? Aren't they in jail?
Somebody can get the death penalty in the United States.
I don't understand that. That argument makes no sense, but that's the argument. I actually had a podcast about episode on this about 10 years ago, where I brought kind of experts in on both sides and couldn't answer that question. It's like, oh, well, of course they have jurisdiction. And then finally, how will this administration's administrative case trains against asylum negatively impact my immigration practice? Well, I mean, it hasn't negatively impacted my immigration practice yet. We're busier than a one-armed wallpaper hanger. But I think there are people that are immigration lawyers that are suffering in this because people are afraid to press their claims. People are either giving up or just literally hiding. Just go to work, come home, go to work, come home. There's a lot of that going on. But this is the first time in my career that I've advised people on what they have to do to leave the United States. I've spent 37 years bringing people to the United States, but now I'm helping people figure out where to go as an alternative to remaining in the United States. I'm not an advocate for illegal immigration, Greg. None of us are. Nobody wants, and none of us are in favor of unlimited immigration. I have some libertarian friends that might be, but I'm not. I think rules are important, rules to file. And frankly, the Biden administration really screwed up in not addressing the issue of illegal immigration at the border. But at the same time, that was more an issue of the laws. They were literally trying to observe the laws Congress had passed, which is basically if you show up at a border, you get to apply for asylum. When they didn't follow that, when they just let anybody in, and I get why people are upset about that. But going forward, the only people that can really fix this is Congress. At the end of the day, the president I don't think he can executive order his way around this. Elizabeth Storm, hi Nina, thanks. With regard to immigration cases, are local and ICE able to work with locals on forms and procedures? I don't know what that means.
I believe she's referring to local law enforcement, but I'm not sure.
Enforcement.
Holy
Local law. Local. I'm just thinking, like, is it the subway going local? Local law enforcement. Well, that's 287G. For example, I live in Tennessee full time, and I've got. I just found out that Tennessee had 11 of our 100 counties were 287G counties, and now 87 of them on the last few months are 287G counties. This basically, 287G exists. It's been around since 1996. Local law enforcement wants to be trained by ICE. They can absolutely, but local law enforcement cannot arrest people for immigration violations. They do not have that authority, but they can detain people for ICE to arrest if they're detained on other grounds. So
in Chuck, a lot of states, including our state, Tennessee, we're on opposite ends of a very long state.
Yes,
there are a lot of state rules for law enforcement now that are running independently of 287G, including in Tennessee.
Yeah. So next question, can you give me the site on the BIA case, which held, this is from Karen Levy, if you came illegally, you can't get a bond hearing. That's matter of Yajuri Hurtado. Yajuri is Yajure. Hurtado is Hurtado. That's a 29 INN Dec 216, BIA 2025. Honestly, it's a really bad decision. Not bad because of what it does, it's actually just a poorly reasoned decision. It was trying to make lemons out of pickles. That's what it was. It wasn't a good result. Maybe they were making pickles out of lemons. I'm not really quite sure, but it wasn't good. Any current litigation on the hold review benefit for people with high-risk countries? That's from Benjamin. Yes, Benjamin, that will be our litigation, which we're filing on Friday.
Yeah, and there's 2 other cases.
There's the one in the Doe versus Noem in Boston, and I don't know the name of Curtis's out in California. You must have read the federal judge joke right there. That was actually quite good, by the way. Any suits filed on behalf of non-citizens under the tort statute? This is the Bivens action. Connecticut is considered to create its own statute that mirrors federal law, but for aliens in its jurisdiction. Would you think this is good? I don't know how they're going to, if it's a local Connecticut statute, I don't know how they have jurisdiction over federal employees. So there are a lot of Bivens actions in process. I know there are, because I was just invited to speak on a Bivens panel next month for individuals. Bivens actions are very hard to win because you have to show them operating outside the scope of the law, outside of the Constitution. Bivens actions are really hard to win, and Supreme Court's made them even harder to win. So I even though the alien torts are available, tough to win. Okay. Vidi Yadav, this is administrations now impose social media vetting before issuing or stamping visas. True. They want people to publicize their social media, which is kind of against their privacy. So basically, if you've got social media, it has to be public if you're applying for a visa. A lot of hackers and scammer ideas. So how is the administration taking measures on privacy? They're not. Their position is, if you want to come to America, there's nothing private about you. By the way, they're taking that decision on U.S. citizens too, just in case you're curious. So there's nothing private about you. So you're better off deleting social media if you want to apply for a visa to come to the United States.
Yep.
So this is a great question. For Texas DACAs, can you have a mailing address but maintain residence in Texas? The answer to that question is no, because one, that's fraud. And as a lawyer, you don't want to be involved in fraud. Two, immigration's not stupid. They run background checks on everybody. And background checks reveal, believe it or not, where you actually live. LexisNexis has this information on everybody living in the United States with a Social Security number. So no, you cannot do that. Good way to go to jail, though. Are credible fear interviews, reasonable fear, still in effect and being implemented? Yes, they are, but it's taking a long time. You don't get rid of 170 immigration judges and think you're going to get caught up. We didn't even mention the fact, by the way, Greg, that they basically offered these jobs to JAGs, and they've already fired one JAG for granting cases. So there you go.
I think the assumption was that the military was just going to go right along, and I'm pretty sure that those lawyers are looking at their ethical obligations.
Yeah, absolutely. Sasha Watson, what are the key fact patterns you should be screening for filing habeas prior to 180 days? Well, first of all, she's referring to Zaidvitas. Zaidvitas is a Supreme Court case. It said that an individual with a final removal order cannot be detained past 180 days without a federal court hearing in which the government carries the burden of proof. So absent a final order case, if you have more than 2 years inside the United States, you can file a habeas to get a federal court judge to order your bond hearing. Period. It's pretty simple. Last one, Greg, here is, have you seen students on an F1 from one of the banned countries be able to get OPT since December?
I have not. And well, I guess the memo went into effect in January, like
January 2, I think.
So my assumption is there were probably some December approvals. I haven't personally seen that, but if you wouldn't see any after January 1st when the second memo went out.
Yeah. So we did. The one we just got yesterday was from India. So it wasn't from one of the banned countries. But again, they're part of our lawsuit as well. It's illegal for the government to do this. They can't not adjudicate cases. They just can't. And they can't use nationality as a basis. They just can't. Greg's been great. Nina, thank you very much.
Yes, thank you both so much.
Arturo and Lavinia too.
Thank you so much, Greg. We always love having both of you here with us. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier today, don't forget to take advantage of the powerful and free legal resource available to Justia Connect members, the Justia Daily Opinion Summaries. You can get next day email alerts with concise summaries for the jurisdictions and practice areas of your choosing, so you can stay updated on anything you may need to know. You can sign up for those at newsletters.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.